We're at the stage we began talking about in jury selection, the penalty phase. In this part of the trial, you as jurors are now going to be asked to ultimately to make a recommendation regarding the sentence of the defendant, assuming, of course, as the judge explained, you find unanimously at least one of our aggravating factors is proven beyond a reasonable doubt. The state submits to you, we have 4 aggravating factors in this case that we will prove to you beyond a reasonable doubt. When we get to the closing, we'll be asking you to unanimously, all 12 jurors in their deliberations, find that all 4 aggravating factors are proven beyond a reasonable doubt. The state filed a notice to seek the death penalty in this case and set forth these aggravating factors. The state knows the decision you've already made was a difficult one, and the decision you're going to be asked to make is also a difficult one, maybe one of the most difficult ones you may ever have to face. But I remind you, as the instructions indicated, that we have to follow the law. You have to follow those instructions. We won't be recalling witnesses during this penalty phase. This right now is my opening argument to that. It'll be a few minutes. The witnesses to those aggravators, the witnesses that prove the existence of each of the 4 aggravators beyond a reasonable doubt, have already testified, and you heard their testimony last week. We will refer to their testimony. The photographs that you need to make the determinations in this case have already been admitted. I may refer to those. We may display some of those, but if we decide just to talk about them, you still have them in evidence and you can see them. We and I apologize to you for having to present the kind of photos that you had to see. And because people shouldn't have to look at those things. But our system of justice requires the admission of evidence to prove beyond a reasonable doubt the charges with which the defendant is charged. And those photographs are essential to proving that. I'm going to apologize ahead of time to some of the arguments that I'm going to have to make after we begin the actual penalty phase and talking about those aggravators, because some of those things that I might say are things you shouldn't have to hear, and things that people shouldn't have to relive, but they need to be done so you can make your determination about those 4 aggravators. If we don't go through the pictures, remember you'll have those in deliberations and you can refer to those. But let me talk a little bit about aggravators. What are aggravators? Simply put, they are circumstances which increase the gravity or seriousness of the crimes with which this defendant is charged. That's all it is. We can read 10-minute instructions to you all day long, but that's what it is. Something that makes the crimes which he committed worse, more grave, more serious. The kind of factors which makes what the defendant did to Robin Cornell and Lisa Story so grave, so serious, that death is the appropriate recommendation, that death is the appropriate sentence. Lawyers and judges have come up with instructions to tell you jurors all sorts of things. We started, is it now 2 weeks ago, with the preliminary instructions for the jury panel as you sat as a group. It took about 40 minutes to read. When your group was selected as the 16 to hear the guilt phase, again, you were given another preliminary instruction, another 30 or 40 minutes. Before our opening statements, another instruction. After our closing arguments, the final instructions, the one which you had a packet of in the jury room, which were typed out, I don't know the number of pages, but they were lengthy. And I know that the jurors deliberating on those instructions and comparing them to the facts that we put forward and the photographs that we put forward and the opinions that we put forward, you had to work through that. It took time. It wasn't something you could go in and just take a vote on. So the instructions are necessary. Sometimes they're lengthy. Sometimes they're verbose. You remember, sometimes attorneys are paid by the word almost. Maybe that's where that came from. But really, are the aggravating factors, are they difficult to comprehend? Are they hard to understand? They're really quite simple, I would submit. We all know intuitively and instinctively what things make the murder of a person more grave, more serious, and worthy of the recommendation of death. Here you go. Killing 2 people is more grave, more serious than killing 1. It's not a 40-minute instruction or even 2 minutes. Killing 2 people is more serious than killing 1. 2, killing a person after you have committed other violent felonies is more serious than killing a person without a prior history or record. Isn't that instinctive? Isn't that intuitive? Do we need a formal instruction with legal language to know that? That's what this section of the trial is about. 3, a killing committed after calmly and coolly reflecting over time, a significant time, is more serious than a murder committed in the heat of passion or in a reaction to self-defense or to a threat or to a fight that comes up. A killing committed with a careful plan or a prearranged design is more serious than one that happens quickly and instantaneously like a reaction.
The prosecuting attorney on this case laying out the aggravating factors as the state of Florida sees them, saying to the jury that they're simple. What do you think? Tweet us right now. Let us know at Court TV is our network handle. We'll get you back into the courtroom live right after this.
A disgraced lawyer accused of a disturbing murder.
The victim, his own mother.
Having been on the run for 8 months.
Richard Merritt will now face a jury.
Murdered mom, attorney on trial, today on Court TV.
Meredith was a good girl.
That goodness had been suspended under Jimmy's spell. The spell was broken when the handcuffs went click.
Accomplice to Murder with Fanny Politan. All new episode June 4th, only on Court TV.
Back to Court TV Live, I'm Julie Grant. I want to let you know that things are rolling on in the state of Georgia in the case against disgraced and disbarred attorney Richard Merritt. So the medical examiner who reviewed the report of the doctor who actually conducted the autopsy on the victim, Shirley Merritt, is on the stand right now going through all of the injuries. This is quite a long process, folks. I'm surprised the defense team hasn't just stipulated to this because the cause and the manner of death really really aren't where you fight your fight if you're defense counsel. You fight it in the identity issue. Did the state get the right guy in saying that it's Richard Merritt, this woman's son? So while they're going through, we want to show you, this is a live picture. We have our crew there. We're going to give you updates. But we didn't want to wait to show you what's going on in Florida because the stakes are as high as they can get in the case against defendant Joseph Zieler. This guy has been convicted of 2 homicides of a brutal nature. He sexually assaulted the women, suffocated the women, and didn't face any justice until 33 years later. But this is the most severe of severe when it comes to criminal cases, one where the state is seeking the death penalty. So today begins his capital case, and where we left off a few moments ago, the state was laying out the aggravating factors, the reasons for the jury under the law to recommend a penalty of death for him. Let's go back in together live.
With sufficient time for reflection is more grave, is more serious than a killing without that time to reflect. Aren't those 3 simple? Aren't they instinctive? Aren't they intuitive to you? Do you need an instruction to really know those things? I submit not. Lastly, a killing which is extremely wicked, a killing which is shockingly evil, a killing which is wicked and vile, a killing which is cruel, a killing which is designed to inflict a high degree of pain or utter indifference to the victim, or even enjoyment of that suffering of the other person. A killing which is consciencelessness, having no conscience, or pitiless and unnecessarily torturous to the victim, unnecessarily torturous to Robin Cornell, unnecessarily torturous to Lisa Story, is again a more serious killing than one that doesn't have those aspects. If I were to walk up behind a person with a gun and shoot them in the back of the head, they never saw me coming, they dropped dead, that doesn't have those components. But if the killing involves unnecessary torture, extremely wicked and evil actions designed to inflict pain, and having the victim aware of what's going on, remember 60 to 70 seconds, because we'll talk about that. So when you hear that the state is relying on formal aggravating factors, and if we read that in an instruction to you, it would read like this. The state of Florida notices that the defendant was previously convicted of a felony involving the use or threat of violence to the person. What are we really talking about? We're talking about a killing where somebody has a prior criminal history of violent offenses. 2, the capital felony murder was committed while the defendant was engaged in the commission of a burglary. The intuitive and instinctive thing of that is, if you're committing a felony, the law finds it more serious if someone dies during the felony, because the felony is inherently dangerous. To break into someone's home contemplates there may be someone in there that might resist you and could very well end up in a homicide. So that's the simple way of considering that. The third, the capital felony was committed in a cold, calculated, premeditated manner without any pretense of moral or legal justification. Goes back to someone who's had the time to reflect, someone who's had a prearranged plan. 3 to 5 minutes till someone succumbs to asphyxia by smothering. As to each victim, 3 to 5 minutes this man had to think about what he was doing. That's after the 60 to 70 seconds to lose consciousness. At any point in those 60 to 70 seconds, the person can make the decision, I'm not going to go further and do this. At any point after the 60 to 70 seconds, the defendant had the option to stop before death came to Robin Cornell and Lisa Story. And lastly, the fourth aggravator, The capital felony was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Simply a wicked, evil, cruel, torturous killing designed to inflict pain for time. As we go through the arguments today on the aggravating factors, please keep those simple concepts in mind. It is more serious to kill more than one person. It is more serious to have been convicted of violent felonies before you commit the ultimate crimes of murder twice. It's more serious if you reflect upon and think about and plan what you're going to do. It's more serious to kill in that wicked, evil, vile manner in a torturous way